Welcome back. I hope everyone enjoyed the tacos over lunch and got your fill. If you did not, I believe there is still some left, possibly, afterwards. So this came up a few times, kind of on the periphery in our earlier discussions, but about changing international law. This next panel deals directly with that topic and the issues and criticisms of that possibility. We have three panelists here from your left to right. On the left, we have Kristen Eichenseer. She is an associate at Covington and Burlington LLP's Washington, D.C. office. Her practice focuses on appellate litigation and international and national security matters, including advising clients on cybersecurity issues. Before joining the firm, Ms. Eichenseer served as a special assistant to the legal advisor at the U.S. Department of State and as a law clerk to Justices Sandra Day O'Connor and Sonia Sotomayor of the U.S. Supreme Court, if you did not know that, and to Chief Justice Merrick B. Garland of the U.S. Court of Appeals for the D.C. Circuit. She holds a J.D. from Yale Law School and a Master of Philosophy from the University of Cambridge and an A.B. from Harvard University. She is a term member of the Council on Foreign Relations. Professor Derek Jinks. Professor Jinks is Mars McLean Professor of Law at the University of Texas School of Law and Distinguished Scholar at the Robert S. Strauss Center for International Security and Law, also at the University of Texas. He previously served as the Charles H. Stockton Professor of International Law at the U.S. Naval War College from 2009 to 2010. His research and teaching interests include public international law, international humanitarian law, human rights law, and criminal law. Professor Jinks is a member of the U.S. State Department's Advisory Committee on International Law and participated as a legal expert in the drafting of the Tallinn Manual. Professor Jinks received his BA in Anthropology from the University of Texas at Austin, MA and MPhil degrees in Sociology from Yale University, and a JD from Yale Law School. Sean Watts is a professor of law at Creighton University School of Law, where he teaches constitutional law, federal courts, federal habeas corpus, law of armed conflict, international criminal law, and military law. He also serves as an instructor at the United States Military Academy at West Point in his capacity as lieutenant colonel in the U.S. Army JAG Reserve. His primary research focus is international legal regulation of emerging forms of warfare, like cyber warfare. From 2010 to 2012, Professor Watts participated in drafting the Tallinn Manual on international law applicable to cyber warfare. He is currently a fellow at the NATO Collective Cyber Defense Center of Excellence, engaged in drafting an update to the Tallinn Manual. From 2009 to 2011, Professor Watts served as a defense team member in Gotovina at the International Criminal Tribunal for former Yugoslavia. Professor Watts earned an LLM from the Judge Advocate General School, a JD from William & Mary Law School, and BA in International Affairs from the University of Colorado. First panelist to present will be Ms. Eichenseer.
Thanks, Daniel, and thank you to Meredith and the entire TILJ staff for organizing what has so far been a really interesting event. I hope I can add to the interest in the coming panel. So this panel is on international law reform and cyber war, and the question that I was specifically asked to address was whether applying extant international law is the appropriate approach to cyber war. I think this question really gets at the issue of, is the existing law of war up to the task of addressing new technologies and new weapons? I think the basic answer to that question is yes, but with some caveats. The answer is yes, but it's not a total answer. And I want to think in the few minutes we have here about a couple of questions. The first is to really think hard about this question of whether we should be applying extant international law, and to really interrogate whether that is a universal position, or I think it's one about which there's some debate. But my answer is basically yes, existing law should be applied. But I want to provide some reasons why I think that's the case, and talk also about the limits of applying existing international law and where we might need some new laws. And I want to just conclude also by talking about who should be making this decision and what are the voices we need to be thinking about in thinking about these questions. So the question I'm addressing is what I think of as international law step 0. It's the issue of, is this something that international law addresses and should address? So you may have heard this in the administrative law context with the idea of Chevron step 0. Is this something that Chevron deference applies to? And I think it's similar for international law. We see this question come up over and over again with basically every new technology. There's always a flurry of debate about, is this something that we can deal with existing law, or do we need entirely new law? And I think we need to take seriously whether we should be answering that question, yes. The United States has, of course, taken the position that the answer is yes, that existing law applies. So the U.S. International Strategy for Cyberspace from May 2011 declared that addressing cyberspace doesn't require a reinvention of customary international law or render obsolete existing international norms. U.S. officials have explained that the law of armed conflict contemplates that existing rules will be applied to technological innovation, and that the existence of complicated questions about jus in bello in the cyber context is just a matter of applying old questions to the latest developments in technology. But as cyber war and international law debates have evolved over the past couple of years, I think it's become clear that the U.S. position wasn't necessarily foreordained to be the only position. So in particular, there have been serious questions about whether China, Russia, and other states agree with the United States that existing laws of armed conflict apply to cyber. So in September of 2011, China, Russia, and a couple other countries submitted at the United Nations a draft International Code of Conduct for Information Security. China explained in a press release accompanying the Code of Conduct that the code's aim was to reach consensus on international norms and rules standardizing behavior of countries with respect to cyberspace. The code itself repeatedly emphasizes the need to maintain international stability and security, and it would impose particular obligations on states. So it would require states not to use cyber technology or networks to carry out hostile activities or acts of aggression, and not to proliferate information weapons and related technologies. So China and Russia's focus on this new code of conduct that deals with issues like hostile activities and aggression suggests that they believe that new law is needed. And there may be a couple reasons for that. It may be that they thought that existing law was inadequate, or that they thought it didn't apply at all. Now, we've gotten a little bit more clarity on this in the last year. So in June of 2013, China and Russia, as members of the UN Group of Governmental Experts, joined consensus on a statement that, and I'm quoting here, international law, especially the UN Charter, applies in cyberspace. But that's pretty much all we know about China and Russia's position. We don't have a lot of detail. So I think we are now at the point where there is agreement that international law of some form applies to cyberspace. But this wasn't necessarily clear for the last couple of years, really until China and Russia got on board within June of 2013. But even if we have agreement that some international law applies, that only brings us to the question that I was asked to address, which is which international law applies? Extant, sort of old international law, or new international law? And I think the reasonable position here is to start with existing international law. We're all lawyers or law students. Lawyers like precedents. So that's basically what we're dealing with here. We have existing precedents and existing treaties, custom, et cetera, on the laws of armed conflict. But rather than just saying precedent's precedent, let's start from that, I think it's important to think about why. Why does that make sense here? And I think it makes sense for a couple of reasons. So first, we have decades of practice establishing common understandings about what the laws of armed conflict mean and where they apply, how they apply to particular facts. So applying existing laws of armed conflict gives us an appropriate baseline to start from, where we already have existing understandings, we have a common language, a common framework to work from. Also, applying existing laws of armed conflict moves the debate away from sort of basic legal principles. This was mentioned in the last panel. If you start reopening and sort of start from zero on existing international law, you could end up someplace a lot worse than what we have now. So let's start from what we have and work incrementally. And I think the incremental development is more at the level of applying existing law to facts. And there's a value in starting with existing international law. But I think there are two other really important reasons to apply existing laws of armed conflict. The first is that by applying existing laws of armed conflict, you start with law right now. If we were to start with entirely new development of custom or entirely new treaties, there would be a long period during which those things would be developed. And that leaves the question of what are we doing now? Does that mean that cyber activities are unregulated? So I think to avoid creating that idea that there's a legal black hole until we have a new treaty or until we have new custom, it's important to say up front that what we're doing is applying existing law, and that there is law to apply. And another reason is that we have precedents showing that the laws of armed conflict are actually really adaptable. Some of these principles, basic principles like proportionality and distinction, are very old concepts, and they've survived other developments in the law of armed conflict over the past decades. They've survived the shift to the nuclear age, biological weapons, chemical weapons. They're adaptable, and they've proven to be pretty durable. So that's why I think we apply existing laws of armed conflict. But in applying existing laws of armed conflict, that doesn't mean that that's an easy proposition. As we've been talking about in some of the other panels, there are lots of difficulties and lots of complications in translating existing laws to cyberspace. But I think these challenges in application are beginning to be worked out with projects like the TILJ manual, which we've discussed a lot, and we're also beginning to see states weighing in and taking more granular positions about how particular principles like the right to self-defense and proportionality and distinction apply to cyberspace. And over time, I think we will see more states weigh in, perhaps with the TILJ manual as a focal point as states take these more granular legal positions. But translating the existing laws of armed conflict doesn't work perfectly. And there's some aspects of cyberspace that have no analog or that are just way more complicated because of the networked nature of cyberspace. So, just to take an example, we mentioned yesterday in one of the panels, how do you apply the principle of distinction when I think the figure that was given was 95% of military traffic goes over civilian networks? Does that now mean that all civilian networks are military targets? If so, that's a really fundamental shift and would really break down the divide between military and civilian targeting categories. Even the TILJ manual, as thorough as it is, flags a number of areas where no consensus was able to be achieved. One thing that was mentioned yesterday, and I think this is a really important one, is what about the placement of malware on systems if it causes no physical damage? That's something that I think we probably all suspect is going on quite a bit. And where that ranks in the law of armed conflict is a really fundamental issue, but one that we don't yet have an answer to. I think there'll be a long process of working out how the existing laws of armed conflict apply to cyberspace and to different factual scenarios. And we'll see maybe as this works out in details, particular gaps that will develop that will need new law. And I want to suggest one area where I think that might be the case. This is sort of a different kind of translation exercise. So it's one thing to translate basic principles like proportionality or distinction, but another kind of existing law that we have for conventional weapons is bans on particular types of weapons. This is a long history in international law, so dating back to, for example, the Hague Regulations, the Hague Conventions of 1899, which prohibited dum-dum bullets. More recently, we've seen prohibitions on things like chemical weapons, biological weapons, landmines, and cluster munitions. Now, these things don't have really cyber analogs, but I think the idea of a weapons ban for cyberspace does translate at a broader level. So if you think about what is motivating the bans on particular types of weapons, it's concern about weapons that are particularly harmful or are particularly indiscriminate. So think, for example, of a cloud of chemical weapons that disperses and goes beyond wherever the military hostilities are into a civilian area. I think we might see the same concerns emerge with respect to particular types of cyber weapons. Cyber weapons, on the one hand, are very, very attractive because they offer the promise or potential for hyper-targeting. But even for examples that we've already seen of cyber weapons like Stuxnet, even if they're hyper-targeted, they can escape into the wild and show up on systems that they weren't supposed to be on. Another difficulty with moving to the idea of a cyber weapons, banning particular types of cyber weapons, is that there's a tremendous information deficit about what states' capabilities actually are and what they can do. So I think, unfortunately, banning particular types of cyber weapons is something that we'll have to wait until we've seen additional deployments of cyber weapons. And that's not actually unusual. For most of the weapons bans that exist for conventional weapons, the bans arose in the aftermath of conflict. So the weapons are used, they produce results, people are horrified at the results, and then the follow-on is the ban on the particular kind of weapon. So I just want to add one additional point, which also came up yesterday, but in thinking about how we translate existing laws of armed conflict and what kinds of new law we might need for the cyber realm, I think it's important to think about who should have a voice on these issues. And so far, the development of the law, I think, has reflected who the current internet and cyber powers are. But other countries like India, Brazil, and South Africa are going to be very important going forward. There'll be a huge uptick in usage of the internet and other cyber activities in those countries. And I think there's a danger to creating international law for cyberspace now and saying, we're done, this is it, here it is, we've done it. We've already seen difficulties with this in the context of the Budapest Convention on Cybercrime. So this is the Council of Europe Convention on Cybercrime. And many countries agree that something needs to be done. And the US and much of Europe have said, we've done it, here it is, the Budapest Convention, we've got this framework, why don't you use it? And there's been a fair amount of backlash and limitations on the uptake of that agreement by countries that say, you know, we didn't draft this, we weren't there when this was agreed to, we weren't there when this was negotiated. So even if we don't necessarily think we have substantive disagreements with countries around the world, or, you know, India wouldn't necessarily say something different than folks who are already at the table on these issues, I think for process reasons, it's important to include a diverse set of voices. Because even if you don't have the substantive disagreement, having countries around the world who are maybe not internet powers now, but who will be, feel like they were included in the process and brought in and have developed buy-in before the law is finally completed is an important thing to think about in the development of the law. In addition to this geographic breadth of the conversation, I also think we should think about greater participation for non-state actors. There's a long history of incorporating, for example, the Red Cross into laws of armed conflict discussions. But engagement on cyber issues, I think there's an argument that's even stronger for a broader engagement with non-state actors. As we've talked about, I think in the last panel, many of the networks that are transmitting malware or being used in other ways for perhaps military activities in the cyber realm are privately owned. So private parties have a major stake in what's being done on their property. Also, the risk of harm to non-state actors as sort of collateral damage or being turned into military targets because of what's transiting their network is really great in the cyber realm and maybe even more grave than it is in the conventional weapons arena. So for both of those reasons, I think it's important to think about not just these basic questions, but how we're talking about the basic questions and who's talking about them. Thanks.
Thank you, Kristen. Professor Jinks?
So thanks, Daniel and Meredith, and all of the TILJ editors for including me in the event. It's been terrific. I'm going to talk about some of the impediments that we face in concluding an international agreement on cyber warfare. What I mean by that is some of the impediments that we face in reaching any sort of multilateral agreement on the clarification and elaboration of widely recognized legal principles. And indeed, what we've been discussing for the most part over the last couple of days is the application of widely accepted, well-established principles of international law in a new context, in the cyber context. And indeed, terrifically fundamental questions have been identified. And the Tallinn Manual 1.0 deals with many of these terrifically fundamental questions. What constitutes an armed attack? In a sense, when the Tallinn Manual project was launched, there was sort of fundamental uncertainty about the degree to which the use of force rules applied in the cyber context. To some degree, there still is. Fundamental uncertainty about rules of state responsibility, the scope of sovereign authority with respect to cyber matters, even how very well-established principles of international humanitarian law, international human rights law, might apply in the context of cyber attacks. And there are a whole host of retail-level ambiguities that we might be able to point to, ambiguities ranging from how you define a use of force within the meaning of Article 2.4, what sorts of matters are within the exclusive jurisdiction of states, domestic jurisdiction of states within the meaning of Article 2.7 of the UN Charter, what constitutes an armed attack in the cyber context under Article 51 of the UN Charter. These are in some fundamental sense ambiguities. Now, I don't mean that they are crippling ambiguities on the international plane. I do think that there's a fairly conservative approach that we can take on each and every one of these issues that yields at least partially acceptable, partially useful solutions. But in the end, some measure of difficulty associated with ambiguity, some measure of difficulty associated with application persists, even in the wake of taking this fairly conservative, albeit helpful, approach. The question is whether the international community ought to engage in some robust attempt to clarify what these principles mean in the cyber context. Should we think about a multilateral treaty to clarify the scope and content of the UN Charter regime and how it applies in the cyber context? Perhaps to engage in a project of ratifying on a multinational level the recommendations of the TILJ manual. Should this become a treaty? Or should we have multinational negotiations that aim to resolve these ambiguities in some conclusive way? I think there are at least 5 kinds of difficulties with engaging in this kind of project. And I don't mean these difficulties in any way, shape, or form as a criticism of the sort of standard-setting kind of soft law process that is reflected in the TILJ manual. I think what the international community needs is exactly what it's getting from the TILJ manuals, and an increasingly granular state practice in connection with cyber activities. I think it would be premature and at the moment dangerous to engage in a more formal sort of rethinking of how these well-established principles of the UN Charter, international humanitarian law, international human rights law, and even more fundamental concepts of state sovereignty might apply in the cyber context. And I want to highlight 5 ideas here that I hope will stimulate some discussion. So the first is that some of the ambiguities or gaps in the law that have been identified are arguably overblown, and even if not overblown, I think that the gaps in the law have narrowed considerably over time. So take, for example, the question of what constitutes a use of force, or indeed what constitutes an armed attack within the meaning of the UN Charter. I think that we've seen a remarkable degree of consensus emerge on the international plane, despite the hand-wringing about how trenchant the conceptual problem is supposed to be. I think there's been considerable agreement that we're really talking about a small subset of cyber attacks that would amount to a use of force in something that roughly approximates the conventional sense. Do we need to rethink what our use of force rules mean in the cyber context? I think we would need to have further elaboration of exactly where it is that the ambiguity lies before we would engage in any kind of wholesale project of renegotiation or clarification of what the norms mean. Second point, many of these ambiguities, possible gaps, in fact reflect structural, often intentional and unavoidable ambiguities in the law of war itself. Indeed, many of the problems that we could quickly point to in the context of identifying with any kind of precision what amounts to an armed attack in the cyber context or what amounts to a use of force in the cyber context says more about the state of use of force law, the state of self-defense law, than it says about the fundamental challenge posed in the cyber context. The international community has long wrestled with the ambiguity associated with the idea of a use of force within the meaning of Article 2.4, long wrestled with the problem of which kinds of attacks actually are sufficiently grave attacks to be characterized as an armed attack within the meaning of Article 51 of the Charter, triggering the right of states to act in self-defense. These ambiguities are part of the law that we're applying in the cyber context. Clarification of what those concepts mean in a particular context, even aspiring to do that, might be putting the cart before the horse, and frankly, hoping for far too much. Third, some of the most persistent ambiguities reflect unresolved policy questions, unresolved at the national level, policy questions concerning the role of offensive and defensive postures in national cyber strategies. The U.S. has somewhat reluctantly come to recognize that as a formal matter, recognize that offensive cyber operations are an important part of our military operations and indeed merit the articulation of military doctrine. But the degree to which the U.S. and indeed other states thinks it in its legitimate self-interest to have room to maneuver to engage in offensive cyber operations is not something that's terrifically well understood at all. Until we understand with far greater precision the scope of what states consider to be legitimate activities in the cyber realm, the kinds of activities that they think they must be able to pursue in order to pursue their national interest on the international plane, we can't even really meaningfully begin the project of renegotiating or clarifying the application of these fundamental international law concepts in the cyber context. Fourth point. Negotiation, or renegotiation for that matter, or clarification of the law of war in the cyber context is just as likely to water down central law of war principles as it is to clarify or improve them. This is a point that was touched on earlier and that I want to underscore. It's far from clear that the effect of sustained reflection multinationally on the international level on what constitutes an armed attack will actually yield a terrifically sound result. Substantive issues might be renegotiated in a way that lead to a watering down of the issue. As we say in many law school classes at this school, hard cases make bad law. Do we really want to think through in some sustained way what the use of force rules mean, for example, what some general principles of IHL may mean on the granular level in the context of a difficult case when we don't have authoritatively endorsed specific interpretations of how those rules might apply in other contexts. And this goes beyond it goes beyond substantive issues and in fact reaches issues of regime interaction. One great difficulty that we've had in connection with the global war on terror is the relationship between international human rights law and international humanitarian law. How do these regimes relate to one another? Is there a point at which characterizing a situation as an armed conflict has the effect of triggering one set of rules, international humanitarian law, but deactivating another set of rules? On the view that one set of rules displaces the application of the other, we have a certain way of understanding the relationship between two regimes designed to do similar kinds of work, protect individuals who were made subject to certain vulnerable circumstances. In the cyber context, how are we to think through these regime conflicts? By my lights, it's predictable that we'll have a substantial pushback from human rights constituencies that norm articulation on cyber warfare should be exceedingly conservative, precisely because of a worry about this regime interaction issue. That we don't want to define cyber attacks too broadly for fear that we will displace the application of human rights-related privacy principles in the cyber context. We haven't sorted out on the international plane this grand collision between international humanitarian law and international human rights law in the context of an admittedly somewhat unconventional shooting war, but nevertheless a shooting war. The problems that would likely arise in the context of trying to think through to the bottom how these ideas, these problems ought to be resolved in the cyber context, it presents a daunting challenge. My last point. Many of the ambiguities that we've talked about over the last couple of days might not actually be ambiguities at all. It may be that there is some substantial consensus lurking out there in on the international plane. The reason why it's difficult for us to know is that we have so little in the way of state practice. This is changing, of course, to be sure. And over time, I strongly suspect that we'll get a better sense of where states are and where exactly the difficulties are. But at the moment, so much of what states do in this realm is not only secret. I mean, secret doesn't quite capture it. It's beyond secret, super secret, unknown unknowns, unknown unknown unknowns. You get the idea. It's terrifically difficult even to engage in a rigorous exercise of stock taking when so little of what states doing is kept secret, is made public, particularly given that we have every reason to think that states are energetically engaged in this realm. We just don't know exactly what it is they're doing. We're learning more and more, to be sure, some of it good, some of it deeply troubling, some of it underscoring at least some of these ambiguities. But given the fact that most of what's happening in this realm, at least that involves the exercise of public power, hasn't been made known, stands as a tremendous impediment. And I suspect would be almost an insurmountable impediment in the negotiation of a treaty, since states would need to recognize, in a frank way, what kinds of activities are taking place and what's the most sensible way to regulate them. So, 5 problems, not necessarily insurmountable, but problems that the international community would confront and would need to think through were we to engage in some exercise of making new law to deal with the problems that we've been talking about over the last couple of days.
Thank you, Professor. Professor Watts?
Thank you, Daniel, and thank you to TILJ and to the law school for bringing me to Austin. I really appreciate the invitation, and let me congratulate you on this forthcoming 50th edition of your journal. That's quite a fantastic accomplishment for you, and I'm very happy and excited to contribute to it. So based on the panel's topic, I've chosen to frame my remarks in a way that builds towards some ideas about the future direction of cyber warfare and law and that interaction. But before I talk about the future, I want to sort of trace an arc from the past to the present, if I could, and I'll do that very briefly. I think to say that there's a past to the interaction of cyber warfare and the law of war is a bit of a stretch, right? The stuff is of awfully recent vintage, if you think about it. But the earliest thinking on how the law of war interacted with cyber warfare, I think, was framed early on by some misconceptions about the internet and about cyberspace generally. We touched on some of those in the previous panel. If you look back at some of the earliest legal writings, there are very much these ideas that conceive of cyberspace as an entirely virtual thing, that it is real and not real, that it is ethereal in its nature or even metaphysical. And so there are writers that are advocating it about that time, and I'm thinking maybe mid-90s or so. These writers that say it's a law-free zone. The regular rules cannot apply in one sense. They do not apply in a formal sense, and maybe that they should not, as a normative matter, apply either. This really ought to be a law-free area. There were some exceptions, I think, some voices in the wilderness. One of them is sitting here. I think Professor Schmidt in the late 90s is one person who begins to challenge that, who says, hey, look, I'm looking at my specific area of the law, and I can envision some ways in which it actually might work okay. He writes early on the principle of distinction and illustrates how it might operate pretty clearly in this ethereal, vaporous realm of cyberspace. Just when the debate was getting good, though, I think you see that there's a distraction. 9/11 happens, and a lot of legal scholarship, a lot of attention in the legal academy is drawn away from cyber events and cyberspace and cyber warfare into questions that emerged from the attacks of 9/11. We see a proliferation of articles on detention, of course, and on kinetic or traditional targeting issues, and of course the military commission distraction as well. And by the way, my favorite thing about cyber, I almost never have to talk about detention or military commissions. I'm so sick of those topics. Cyber is a great excuse to never have to write about any of those. You have to do cyber really poorly to get yourself detained, right? So At any rate. So that's kind of the past I would sketch. What does the present look like? Well, so the conference has done a nice job of, I think, informing us of some of the cyber events that brought it back to our consciousness. Stuxnet, of course, the 2007 Estonia event, the 2008 Georgia event, resurrect this discussion about how the law of war interacts with cyber warfare. And I guess not too long after that, we see these pretty shocking revelations from states. Just last week, in fact, well, not last week, this is about the middle of last month, the 14th of February, the United States Army issued a field manual on cyber and electromagnetic operations. I looked really quickly to the table of contents and found immediately the chapter on cyber operations, and it's shockingly frank about our capabilities and our intentions in this area. There's actually a passage in there that refers to lethal cyber capabilities. The Army envisions and is announcing some doctrine for its forces on how to apply cyber warfare and anticipates applying cyber means to achieve lethal effects on human beings. And so I think that helps us with some of the ambiguity with respect to states' capabilities in this area. If you're writing in 2007, you have to be pretty creative to imagine what states are doing. If you're writing in 2013, it's all laid out for you, what they intend to do to one another in this area. So the legal discussion profits from it. Characterizing the state of the law, I'd emphasize, I guess, two things. First, I think, and last panel and two papers that I've recently read made me rethink this, but I'll put it out there anyway. I think that you find at present the majority view is to discredit this ethereal conception of the internet. That for the most part, the majority view is that most of the internet is actually tangible enough and exists in places over which states exert sovereignty and jurisdiction to the extent that we can safely say that it is a real thing. It consists of cables, it consists of servers and processors and nodes and satellites in the infrastructure sense, and it consists of acts by real people. Real people do things in cyberspace. They may interact in a virtual sense, but the people who conduct these actions are very much real persons who are traditional to, or are subject to traditional notions of state sovereignty and jurisdiction. So the legal conclusion that follows from that debunking, if you will, of the ethereal internet is that, as Kristen suggested earlier, the existing rules actually apply. Now, that's a separate question from whether they work. I just want to say this, that if you look at the thresholds that guard the operation of the law of war, or the thresholds that we find in the United Nations Charter use of force regime, they very clearly apply to cyberspace. You can translate those concepts, you can try to operationalize them. In fact, this is the central thesis of the Tallinn Manual 1.0, right? That the existing rules at least do as a matter of law, lex lata, actually do operate when states undertake activity in cyberspace. So this is nice too because it's confirmed by states. Kristen earlier mentioned the U.S. strategy for cyberspace. I would add to that the U.S. view announced by Dean Coe in his remarks at Cyber Command in, I think, September of 2012. He actually poses himself a series of 10 sort of rhetorical questions about law and cyberspace, and then he answers them with some elaboration. It kind of reminds me of the old law school urban myth of the professor who gives an exam, but she doesn't write any questions. You have to write your own question on the exam, and then you have to answer your own question. And your grade is a function of the quality of your question and its difficulty, and then the quality of your answer to your question. I got to say, if I were grading Dean Coe, I might give him a gentleman's C on his questions and answers in that speech. Although, I guess, wait, you don't grade him at Yale, right? So I guess I can't grade him. But at any rate, if you're familiar with what he's saying at this thing, you know, I don't know. It's, to use Kristen's term, we're not getting very granular there. When he's saying, is cyberspace a law-free zone? Yes. Or no. No, he says no. He says, does the principle of distinction apply in cyber? Yes, and with a little elaboration. So it is very much clear, I think, at present. We can say with some degree of certainty at present that both the Tallinn Manual and Dean Coe's remarks are correct, that this existing international law does apply in cyberspace. But to the extent the extent to which it is adequate, I think, is a very different question, which Derek, I think, addressed exceptionally well. Last, so what does this future look like? Well, you know, if I could write this future, I would put the Tallinn Manual out of business. I would say that Eric and Mike and I should not have a job, and nor should Wolf. I would much prefer to see states sitting around the table 4 times a year, trying to hash this thing out and then finally putting their names on it. Is this likely to happen, though? No, I don't think it is. And I'll use the past to illustrate why, and I'll use a bit of the present to illustrate why I think that is. I've got this idyllic notion of the old law of war. I'm too new to this stuff to testify to it personally, but if you look at the old documents of the law of war, and if you look at the paper trail left by our predecessors in the law of war, you get the sense of a really vibrant discussion, a discussion and development of the law that happened outside of diplomatic conferences, that happened at academic conferences, that happened in interactions between non-state actors and representatives of foreign ministries and representatives of departments of state. I have the picture I've begun to develop is one of a really vibrant and pluralistic exchange between military and civilian contributors to the law of war, between state actors and non-state actors. The ICRC produces rich and interesting commentary on the law of war, and not long after that you'll find state commentary on those documents. Pictet's commentaries come shortly after the Geneva Conventions are concluded in 1949, and not long after that you have what I still think might be the finest exposition on the law of war ever written, the Army's Field Manual 27-10, written by Richard Baxter from Harvard. And so, looking back, I think there existed for a time a really interesting and diverse and vibrant exchange on the development of the law of war. And if I have to concede, a diehard positivist that I am, diehard sovereigntist that I am, that law does change after the treaty is ratified, that it was a really rich process of evolution that actively involved both states and non-states in its process. I don't think that's happening today at all. I'll just give you a couple of examples. First, in 2006, the International Committee of the Red Cross publishes a giant study on the law of war in its customary state. They call it their study of the customary international law or customary international humanitarian law study. This thing runs in its rules and commentary to well over 300 pages, I'd say. But the real magic and the real work in the thing are in the 2 volumes that support that primary work. So all told, the thing runs to about 4,000 pages. It is a remarkable work of law of war scholarship. I concede that wholeheartedly. The reaction it drew from states is entirely underwhelming. The United States, who I know for sure has positions that are directly at odds with the substantive conclusions of that manual, manages to muster a 28-page démarche, a short letter that's focused mostly on the methodology of the International Committee of the Red Cross and really doesn't address in any substantive way the objections to the legal conclusions in that manual. That's one example. A further example, so Daniel was generous to mention my involvement in a case at the ICTY. This is the Gotovina case. The trial level judgment in that case was issued and it ran to 1,400 pages. And I had to read those 1,400 pages. Fortunately, they were billable hours, so I thank the ICTY judges for that. But I know also, and this formed a big part of my involvement in the appeal work on that case, I know that a lot of what the court said about the law of war, a lot of the legal conclusions that undergirded the convictions in that case were directly at odds with NATO understandings of the law of war and with United States understandings of how the law of targeting operates on the modern battlefield. And try as we did, Professor Jeff Korn was involved with the co-accused of my client. Try as we might, we could not muster an effort from anyone within the United States government. And no response whatsoever to that 1,400-page pronouncement on the law of war. war. A further example Professor Schmidt mentioned earlier, of course, is the DPH study, the ICRC issues its study on the meaning of direct participation in hostilities. Again, elicits almost near silence from the United States. And here's the problem. And it's not just a sad comment on the quality of discussion. It's not that the discussion is poorer because it doesn't have this pluralistic aspects of development that I detected from long ago. It's that the international community, be it scholars, be it judges, be it operators, frankly, are starved for answers to these questions. And these pronouncements from the ICRC, from ICTY judges, are ruling the day. People by default are resorting to these sources rather than to sources that emanate from states, and so this is a terrible thing. This is a sad thing, and I think everyone is worse off for it. Can we expect something different in cyber? I'm happy to say, as a participant in the Tallinn Manual, that the reaction has been mostly positive. That's a good thing, certainly for us as authors. But boy, when that many people from that many backgrounds get together and write something to that level of granularity that you find in the Tallinn Manual, I sure would have expected a reaction from the United States government, and something more than 10 questions, with brief answers at a ceremony at Cybercom. The state reaction has been underwhelming, and so. It just is. And now I guess the last question I'll get to in closing is why? Why is that? And is that appropriate? Derek touched on this. I like Derek's points about ambiguities especially. If I could add a sixth difficulty with respect to these ambiguities, I think it's some efforts to add granularity to the law of war as it applies to cyber might also encounter the difficulty that some of these ambiguities are quite deliberate. That states know it's ambiguous, intend it to be ambiguous, and prefer that ambiguity. And if that's the case, I'd love to see them out there defending that ambiguity. Don't let creative scholars run away with the law of war by creating new rules that aren't rules, by suggesting norms that exist that don't really exist. The states can't let this conversation run away from them, especially if you mean to defend some of those ambiguities as a matter of self-interest. Why else might states do this? They might do it because they think it's in their interests not to be involved. I think we saw this very early on in the detention debates, right? So you had to wait for these policy memoranda, even if you were a member of the United States government charged with instructing officers and military lawyers in the law of war, you had to wait for these things to leak, to hear our legal reasoning that undergirded the detention policies and procedures that we undertook very early in the global war on terror. That just, to me, is unfathomable. Why a state would shield its own lawyers from the legal conclusions that undergird that. There are important points about the law of war in those memoranda. Now, some of them I think are just axiomatically wrong, but those I think overshadowed a number of important points about the application of the law of war, what a common Article III conflict means. There are some colorable arguments about the law of war in those documents that were frankly hidden from, not only from the larger debate about what the law of war means, but from the law of war specialists within the executive branch itself. And then secondly, a second example, I guess, of perhaps government shrinking away from developing the law of war, taking part in this discussion, is the drone debate, right? I really get the sense, first, I'm not one who likes to make a lot of the drone issue. I think a lot of the legal problems with drones are overblown. I really do think of them as just another means of warfare. If there are interesting questions surrounding drones for me, they're more of the jus ad bellum nature than of the jus in bello. I really have a hard time finding interesting things to think about drones in the jus in bello sense. But look, I very definitely have the impression that the U.S., to the extent it's suffering criticism or is losing the public debate on drones, it's its own fault. again, we've let the legal discussion run away from us. It's too little, too late. There is, of course, a flurry of policy statements from folks in the White House. I think John Brennan comes out. I think we see something from the CIA legal counsel. We see something from the new DOD general counsel on the legality of drones, but too late. We'd already lost the debate. The momentum was picked up in favor of Human Rights Watch and UN reports and other non-state actors really took control of the legal debate in a way that probably that states shouldn't have allowed to happen. So this is a downer, right? This is kind of a pessimistic way to close the panel, and maybe we can turn it to a happier thought, but I'm awfully pessimistic about states' involvement here. I think it would require a substantial change of thought or change in policy toward legal ambiguity for us to see states reemerge as the meaningful participants or the leaders in the development of the law, even in this really important area of cyber warfare in the law.
Thank you, Professor. Do any panelists have any responses to other panelists? No. So I have a few questions. One, it seems like the reason why we're probably here in this room and this debate is happening is cyber warfare was something new. I think it's debatable in which way it was new, if it's just technological, if it's something that's completely never been seen, or if it can be fit into existing law. I was wondering, we talked about drones potentially, or Professor Watts just talked about drones potentially, and according to some people, causing difficulty in the application of law. Is there anything looking to the past, similar challenges either from technological development or from other changes outside of the law that have created this much difficulty? If anyone wants to take that. Or Professor Watts?
One of my favorite law of war stories that I like to teach, or I like to tell when I'm teaching, is about submarine warfare. And so yeah, I use this to illustrate the difficulty of legislating prospectively in the law of war. If we can critique commanders for training to fight the last war rather than the next war, I think we can critique international lawyers, law of war specialists, for legislating the last war rather than the war to come. But is that really a critique? Because there was an experience at legislating a little bit more prospectively. It came after World War I, so there were horrors associated with the use of submarine warfare, and in 1938, states finally concluded through the London process a set of rules that would apply to submarine attacks on merchant shipping in particular. They came up with this elaborate set of rules that included a requirement that the submarine surface, before it was going to sink a merchant ship, that it announce its intention to sink that ship, provide that ship an opportunity to evacuate civilian personnel and crew members, and then after these elaborate processes, then the submarine would be lawfully cleared to attack the merchant ship. That didn't work, right? And so World War II happens, and Admiral Dönitz, the chief of naval operations of the German Navy, is brought up on charges, including violation of this London process. His submarines in the Atlantic theater had not been surfacing, had not adequately given merchant ships an opportunity to evacuate their crews, and so he is charged with a criminal violation of that rule. And the featured aspect of his criminal defense against those charges was a set of interrogatories that he posed to Chester Nimitz, the American chief of naval operations, who in essence, in other words, says, yeah, those rules were garbage, and we blew them off. We didn't follow those rules either. Now Dönitz is technically convicted on those charges, but the judges at Nuremberg made a point of saying that his sentence, his prison or confinement sentence, did not include was not based at all on his violation of the London process rules for submarine warfare. So, I mean, look, it's anecdotal, but that is a glimpse into our track record of legislating too quickly or legislating prospectively in some sense.
Thank you. Does anyone have anything to add?
The only thing that I would add, is that we saw similar sorts of discussions in very early on in the global war on terror. When it was as early as, I think, January 2003, that the Alabama process, I think I'm remembering this correctly, was initiated, partially supported by the Swiss government, to consider whether we need to modify existing international humanitarian law, possibly draft a new additional protocol to the Geneva Conventions to regulate transnational armed conflicts against terrorist groups. The thought was that we really needed to rethink almost every aspect, or might need to rethink almost every critical aspect of IHL. Conflict classification rules didn't fit. The principle of distinction wouldn't work in the way that it does in conventional conflicts. Status categories wouldn't work in the way that they have in typical conflicts. Detention rules, I mean, all the way down the line, the thought was we might really need to engage in a fundamental rethinking for this new world in which states are going to be engaged in trans-territorial conflicts with private, far-flung, loosely affiliated private armed groups. Cooler heads prevailed in that context, but it does underscore that this impulse is not a new one. The idea that everything has changed, that we might need to fundamentally rethink our existing principles. The take of experts in the Alabama process was we ought to make very clear that a new treaty is not necessary, that existing principles are up to the task. It's similar to the impulse adopted in the Tallinn Manual Part 1, and the sensible course in that context. But I think it's easy to think when it's far from obvious how rules ought to apply in an importantly different context, that we need to fundamentally rethink the principles. But what was really driving the idea that we needed to fundamentally rethink the principles was really some of the other difficulties that I pointed to. I think it really had to do with difficulties that inhere in existing international humanitarian law, lack of clarity about where exactly states stood as a matter of policy and as a matter of strategy on what exactly they wanted to be able to do, what exactly they wanted to be able to say was unlawful for other actors to do. And until those matters were clarified, it was really difficult to say that we really don't need this effort to rethink fundamentally the rules of war in this context.
Just to add on to that quickly, I think it's also important to think about, this is something I said in my presentation, we get this same question over and over with every new technology, with every new development. It's like, oh, do we need all new law here? And I'm not sure, I've given some thought to this, but I'm not sure why that happens. Is it just that every time there's this new technology, there really is profound confusion? And people are thinking, well, maybe it would just be easier to start from scratch and start with new rules. Or is it, and I guess this is where I would tend to, my cynical side comes out here, I think it's probably that argument is more pushed by people who are dissatisfied with how they think the existing laws are going to apply, and they're using it opportunistically as a space to try and rewrite everything and rewrite it in a way that suits their interests. But I think who is advocating for the totally new law changes over time in different scenarios.
Well, and we can turn the mirror on ourselves here and look at the academy as well. The pressure to be original, the pressure to say new things that haven't been said before generates some of this as well. I think it comes from us. And look, when you have states that aren't reacting to that, again, to beat my old drum, when someone says something crazy about the law of war, and no one's from any authoritative source steps up and says, no, that is exactly wrong. You have got the law exactly wrong here. This is the law. This is how the law operates in this circumstance. Let us reiterate our position. Well, these crazy ideas, original ideas, they're great for getting tenure, but they really gain a momentum that they might not deserve.
Thank you. To go back to another part of Professor Watt's discussion, he talked about the lack of state involvement in the process and in the discussion. Is there anything that any of you, Professor Watts too, but if you would see changing that or changing that in the future, or how might that change? Was that, we're just, so we give a hypothetical. What if there was a significant cyber attack involving a major country, US, China, on the receiving end? Would something change after that?
I mean, I don't mean to paper over or make it sound like these states have been negligent. My sense is that they're hostage, in some sense, to their own processes. If you can't get a law of war manual out for 40 years in the Department of Defense, it's not because someone's lazy, and it's not because someone's asleep at the wheel. I think interagency friction and bureaucratic infighting have a lot to do with this. But, you know, I come from an environment or from a professional background where leaders took care of that. It was leaders' responsibility to sense that was happening, to sense that our interests weren't being served by something like this, and to intrude and say, no, this is going to happen, and to lock people in a room and make them say something meaningful that does serve our interest.
One possible driver that might encourage states to say more, and you may be able to speak to this, Sean, you probably can. Mike, what has been the reaction to the Talon Manual among operators? I mean, my very impressionistic sense is that operators, commanders, are eager for guidance on legal framework, and it may be that you have sort of bottom-up pressure within states, driven by actors on the front lines, more or less, who have to make these kinds of judgments and don't have much in the way of guidance from their higher-ups, and look to things like the Talon Manual, look to things like academic writings, and either act on them or kick it up the food chain for possible approval. I mean, I would think that would be a significant driver, but then again, I would have thought that would have been a driver for years and might have led states to do more than they have. But I would be curious to know more about that. I mean, maybe that's one possible way in which, or one possible avenue along which we might have more granularity develop in state practice.
I mean, I think the hypothetical you posed may be right. I think that in the wake of an incident, we would be more likely to see legal arguments come out from the United States, from other states. I think that the government typically doesn't like to say anything until they have to, and then they say nothing more than they need to, or what they perceive that they need to. So it's really hard to get the government, the entire government, in an interagency process to agree that they have to say something and what they have to say. And you know, I think that the scenario you posited, in the wake of an attack, or as the victim stayed in an attack and making arguments against another state, may be the kind of action forcing event that would be required. Ideally, we might want to have more legal clarity and more sort of rationale out there to be debated well in advance of a scenario like that. But it's hard to get the government bureaucracy to move, and it's hard to get them to do things publicly. So what you're positing might be the most likely outcome for how that'll happen.
Thank you. So we'll take questions from the audience now.
Okay, so I actually have a couple of questions. First, for Kristen, you mentioned that non-state parties should have a stake in it, specifically private companies, should have a say, should have a voice in kind of the ongoing dialogue. And I was wondering what that would look like, what you think it should look like, what it does look like currently. And then the second question is, I was kind of intrigued by when you said that we're an area of law that we might actually have some kind of explicit law on is a particular ban on a particular weapon or use of weapons. And I'm interested to hear what Professor Jenks and Professor Watts have to say about that, especially considering Professor Watts' comment that it's already laid out in front of us what states mean to do with these weapons. So
on I guess what I was really advocating is non-state parties. So obviously the ICRC has been involved in these issues for a long time, but I think that private parties do have a big stake in these issues, and we're seeing that now where private parties are being accused of acting with governments or acting at the behest of governments, and they're being drawn into these sort of more fundamental security debates in a way that I think they aren't in many cases in a non-cyber context. So how and when and how what this would look like, I think is, it's partly on them to be following developments like the Tallinn Manual and to be offering their input. And I think it's partly, when you all go on your listening tour for the Tallinn Manual, to reach out to folks who you think would have interesting perspectives, whether it's the geographic diversity I was advocating, but also having a forum where you would have, obviously academics are well represented, but you could have industry, you could have all sorts of folks who are interested in privacy issues, or individuals who are not as necessarily focused on the law of war, but who have sort of collateral interests that would be implicated by the law of war rules that are being worked out. So I think it's a process of dialogue. That's what I was meant to be suggesting.
All I will say about this idea of sort of a cyber arms control kind of approach, I think it's an interesting idea. As I understand it, it's correct to say that it's one form of international cooperation that may be likely, may be possible. I certainly like the fact that it doesn't involve revisitation of some of the fundamental principles of the UN Charter or fundamental principles of IHL. Per se regulation of certain kinds of cyber weapons might be a sensible kind of approach. I'm skeptical about whether we get too terribly far, that how broadly these categories would be defined, how much this kind of approach would actually satisfy the relevant constituencies. There, I guess I'm more skeptical, but I certainly suspect that it's more likely that you could have some form of international cooperation along those lines.
My familiarity with the existing bans on weapons, or the existing instruments that ban certain weapons in war, is that I think banning cyber means would present an immense technical challenge. What I've learned about these means during our consultations with the technicians suggests that they really are ever-changing, and that some are simply one-use weapons, that they are tailored particularly for a specific target, a specific system, and can never be used again. And so I wouldn't underestimate the technical challenge of describing them sufficiently that we could achieve the object of such a ban. And then the second concern is many of the existing means for banning weapons include verification procedures that I think would also be very difficult to replicate in a cyber context. How do you inspect? What would I be looking at? How would I verify? The trust but verify model would be very difficult to apply, I think, in that context.
Can I just briefly weigh in on that? I think that's absolutely right, that the verification challenges for cyber are more challenging than for other types of weapons. But I think where it could be useful, and it is, as with so many things, may need to be tweaked for the cyber context, would be to talk about the effects of weapons. I'm not sure there would be any technical way to verify that a state doesn't have code that would do a particular thing. That seems to me very difficult. So maybe you don't get to the same level of destroying stockpiles that you have for other kinds of weapons bans. But if we might want to define the weapon in a different way, like define it by its effect. So this, I think, probably doesn't reach the level of things I would think may happen in the future. But you can imagine, for example, banning cyber weapons that would have the effect of erasing data or wiping computers as opposed to corrupting data. So you could define it. Just to be clear, I don't think we are anywhere near getting a total ban on either one of those things. But you could define it sort of by its effect, and then verifying becomes a little bit easier because once you see the effect that the weapon's been used. But there are tremendous verification challenges that would come along with it.
Well, I think there's absolutely no need to ban during armed conflict because we already protect persons and objects. It's extensive, so you can't shoot at them anyways. But I think it'd be very interesting below the armed conflict threshold to think in terms of a ban on striking certain targets. Because you're exactly right. It would be almost impossible to craft the ban on the weapon, on the malware, et cetera. But it might not be impossible to craft a ban on protecting certain systems, such as critical infrastructure, short of an armed conflict. And I think that may be the way out of that problem. And then, Kirsten, I've been thinking a lot about the question that you asked. Why are people always upset? And I started thinking back through history, and people seem to get upset when weapons have new effects. So if I think back, think about the crossbow. Why did we ban the crossbow? Or why, I didn't actually ban it, I'm not that old. But why the crossbow? Well, the crossbow because it enabled you to kill people at great distance. And that just didn't seem chivalrous. Or why the airplane? Because now the airplane places the civilian population at risk. Or why were there discussions about the machine gun? Well, because it killed a lot of people all at once. Why discussion about drones? Because it allows me to kill you without me assuming any risk. Or autonomous weapon systems. Why? Because only man should have the ability to kill other people. And in cyber, it's all about it affects everyone. Almost everything we do today is wired. So, now why is there no faith in the law? Because when we look at humanitarian law, we almost only see the violations. No one's reporting on how well U.S. forces in Afghanistan are complying with the law of war, or Dutch forces, or what they do is they report on the violations. So when you see this new effect that shocks your conscience, you know, holy cow, it can affect my kid who's on her iPhone, or holy cow, I'm going to be killed by a robot. You know, somehow, when that happens, you think about the law, and what you conclude is the law doesn't work very well. So you lose faith in the law, and so you don't, you know, you assume it's going to fail because it failed in these instances that you knew about. So I think that's the problem. I mean, I just came back, as I mentioned, from an autonomous weapons, and there were the most fantastic claims about what these things would do. And there was just no belief that states would follow the extant norms whatsoever. So they don't follow the extant norms. What do we need? Well, my God, we need new norms. That's it, new norms. And I think it's just natural. We see this with virtually every new weapon system that comes out that has a unique effect, an effect we don't understand. The only other thing, and it's very brief, with regard to whether or not international law applies to cyber, I would say there was some discussion about IHL, but not much. The discussion was all about the jus ad bellum. It was about whether or not the principle on the use of force, you know, the prohibition of the use of force, Article 51, self-defense, whether that applied in an environment that wasn't kinetic in nature. But with regard to the IHL, pretty much everyone said yes, and there's a reason. It has to do with Article 36 of the additional protocol, which says that, which, by the way, most states, including our own state, recognize as customary in nature, at least an aspect of it, which says that, listen, if you have a new weapon system, you have to do a legal review. Well, I mean, think about it for a second. What are you going to review it against if the law doesn't apply? So cyber is a new weapon system. Everyone agreed cyber was a new weapon system because it can kill on a battlefield and so forth. So there must be a legal review. What do we review it against? We review it against IHL, as we've done every other new means and method of warfare. So that debate sparked momentarily, and then people started saying, yeah, whatever, 36. And then they get it, they'd be embarrassed, and they go away. And the attention is focused primarily on the jus ad bellum. Although I think that's dying away. I don't think there's much of a debate anymore. As you correctly note, recently, you know, we were just at a conference with Chinese and Russians, and no one was suggesting, from these countries was suggesting that IHL didn't apply, that jus ad bellum didn't apply. No one even suggested that the law of state responsibility did not apply. In fact, they're willing to accept the ILC's Articles of State Responsibility entirely, in its entirety, even though it's not hard law.
Other questions?
So, Kristen, we talked very briefly yesterday about the difference. One of the fundamental differences that cyber brings is that it's not monopolized by the state. And I think that's one of the reasons why weapons control agreements are going to be completely ineffective, is because there are only states who are making tanks and nuclear weapons and things like that that are covered by existing treaties, but anybody can put together a cyber tool. In fact, the vast majority of cyber tools that are created and available are not made by states. And so until you get a weapons treaty regime that covers individuals, it's not going to be effective. And I guess you can round that back to the idea that a state has an obligation to make sure none of this stuff comes out of its territory and creates transboundary harm, but that's really then again about the use, not about the creation. So I think that's a fundamental problem with using weapons control in this area. Now, Derek, I wanted to ask you about this ambiguities. Sean made most of my point. I think these ambiguities are purposeful. I think states clearly don't want to box themselves in yet, particularly the advanced states. They want to maintain complete freedom of action until the point comes where their freedom of action, I mean, it's a balancing, right? Their freedom of action now is not as important as their protection. And so my question for you is, if you believe that, then are we at a point where we have to wait until China and Russia have stolen enough technology from the U.S. and the U.S. has stolen enough back that now there's nothing left for the three major stealers to steal, and instead we turn our focus on those who are now trying to steal from all three of us? I mean, is that the point where we eventually then say, okay, now it's in our interest to close these gaps, to solve these ambiguities, and that we just have to just kind of get used to the idea that we're not going to get any international agreement, any substantive international agreement until then?
Yeah, it's a great question. I don't know. Maybe. But I'll say this. I think that part of what your question underscores is, and this dovetails with Mike's comment about the fact that much of the action early on was in the jus ad bellum, even though that may also be dying down. I think part of the reason why that's so is the international community was thinking through the idea, or playing with the idea of a new concept of violence. And I think that that various cyber-related constituencies wanted to have the issue of an armed attack and use of force resolved one way or the other, depending on where they stood on this debate about whether we ought to recognize new forms of violence. Forms of violence that may not only are they not kinetic, but they may not at any point produce an actual kinetic effect that looks at all like a conventional use of force. Some push for the idea that even those kinds of attacks ought to be regulated as stringently as possible on the international plane. We need to have some kind of vigorous response, not only in international law, but some robust authorization for states to take unilateral action to address instances where states or other actors engage in conduct that maybe doesn't amount to a conventional sort of armed attack. So when you say instances of cyber theft or acts of espionage committed through the cyber realm, I don't think states are motivated to articulate granular views on the jus ad bellum or IHL or state responsibility when it comes to those kinds of acts, because that would require fundamentally recasting the use of force rules. If states were interested in fundamentally rethinking use of force rules, possibly broadening it to include acts that don't fit the conventional profile of an armed attack or a use of force, I think we'd see much more in the way of granular state practice, granular state views on a whole host of topics. But I think states are willing to deal with some of the difficulties that you describe, and the byproduct being that the cyber realm is a little bit like the Wild West with respect to some of these kinds of activities, because we don't have a legal framework that's a good fit in the absence of either a new treaty that doesn't have anything to do with the law of armed conflict, doesn't have anything to do with the use of force, it has to do with transnational law enforcement cooperation, or has to do with the regulation of international espionage, or has to do with cyber theft or something along those lines. And it may well be that state interests end up lining up to the point that we have an international cybercrime convention with real bite, that we have meaningful transnational law enforcement cooperation, that we have regulation of international espionage, at least in the cyber context, or theft, at least in the cyber context. But I don't think those kinds of considerations exert much pressure on the debate that we're describing here, the use of force and IHL debates, the cyber war debates, because they don't neatly fit or even really fit at all in a war paradigm. But what I'm trying to underscore here is I do think there is this constituency for broadening the concept of war. I mean, Mike mentioned earlier about, and Sean alluded to the idea that really the early debates were about this notion that cyber is virtual. And could we say in any circumstance that a cyber attack amounts to an armed attack? They're two fundamentally different things. It's comparing apples and oranges. And clearly there's been real pushback on that point. And there may well be an emerging consensus. But I think there remains a constituency for the idea that existing use of force rules are inadequate, not because there's a disagreement about the best way to interpret existing use of force rules or that there's a best way to apply those existing rules to a new technological context, but instead because there's an evolving sense of what ought to count as the most supreme forms of violence, and that it goes beyond kinetic. Something like the interruption of service that we saw in Estonia in 2007, even if it doesn't cross the threshold of an armed attack, even if it doesn't cross the threshold of the use of force, is such a fundamental interruption of the daily life of the peoples of Estonia that they want it to be recognized in international law as some grave breach of a fundamental principle that ought to trigger the right of other states and Estonia itself to respond as vigorously as possible. All of that, it seems to me, is what drives this we need clarification of the use of force, the ad bellum side. And maybe it's dying down. Maybe a consensus is emerging on this, what I called in my talk the conservative approach, or a conservative approach to use of force rules. But I think there's this larger this more fundamental demand that exists out there to rethink violence on the international plane and our regulation of violence. If we relent on that as an international community, if we actually are willing to recognize unconventional forms of violence and recognize that we need special kinds of rules in those contexts, that will involve the kind of fundamental rethinking that I was describing in my talk. And I don't know what it'll take to prompt that kind of action on the part of states. I do think it would take something like the sort of absurd state of affairs that you described in your question. It really would need to be pushed that far before the actors are willing to fundamentally rethink the nature of the enterprise. But I think there's some pressure to rethink the nature of the enterprise. It's not simply this very small sliver of cyber that is regulated by IHL or that implicates the UN Charter that interests the constituencies out there. They want this law to do more work than it plainly does on its best construction, as the Tallinn Manual's made a very persuasive case. The big question for me is what's going to happen to sort all that out? Will that constituency carry the day? Will it die away? Will there be any law reform efforts to try to articulate a special regime for unconventional uses of force?
I'm supposed to, like, I'm not asking any questions.
So if I can just ask you a follow-up question on that. So how do you see that happening? I mean, I'm envisioning the United States contacting China and saying, look, your guys have broken into our system and stolen our stuff, and we now think that the law has evolved to such a way that that's really a use of force, whether this is the stock market or whatever the target is. And so then they say to China, the next time that happens, we're going to respond with force. I mean, is that how you see that discussion taking place to move the ball forward? Or do you see this, I mean, you're obviously skeptical about everybody getting together and signing a treaty. So how do you see that evolving?
It's possible, something along those lines, yeah. I think something like that, I mean, that's a greatly simplified description of how it would work, but quite possibly. Look, at some point, states are going to have to push for, if this view is to carry the day, states are going to have to push for the right to act in a robust way, unilaterally, in response to cyber attacks that may or may not fit into this conventional description of a use of force, that may or may not amount to an armed attack. Is it likely that what you just described is going to bear fruit? The U.S. picking up the phone and saying to China, the next time you should understand, we think this is a use of force. Likely not, right? But over time, if actions are taken to push the threshold down or to carve out room to maneuver, even in the absence of any finding that there's a use of force, that maybe we need to broaden our understanding of maybe the UN Charter is hopelessly outdated, because in this networked world, an equivalent level of suffering can be caused via, non-kinetic means, even in the absence of producing any kind of direct destruction of property, direct threat to individual lives, simply through what we might call cyber theft, or interruption of access to service, or the erasure of data, or even taking data temporarily, or making data inaccessible temporarily. Is there going to be a point at which we have the view, carry the day, that ought to be understood in the same way that we understand dropping a bomb? I'm not suggesting that ought to be the view. I'm certainly not suggesting that. In fact, I don't think it ought to be the view. But I do think that's part of what's going on in this debate.
I think this is a very interesting discussion. It seems to me, though, that states are beginning to set forth their position. I was really struck, Marco mentioned it as well in his presentation, the Dutch and the AIB report that's been accepted. I mean, they clearly say that armed attack does not require, death, injury, damage, or destruction. And the U.S., with their lack of a gap between 2.4 and 51, would seem to say the same thing. So it seems to me that we're starting to get, states are starting to come online, at least with regard to cyber activities. What strikes me, though, is that this is a fundamental change in the way we look at the notion of armed attack, because remember, we never have looked at it as severity. We've looked at it as nature. It was about damage or injury. We all accepted that, but remember, we ruled out economic warfare. And everyone would agree that economic warfare can cause consequences that are far more severe than lower level damage or injury that would qualify as an armed attack. So I thought your point, Derek, was very, very interesting when you said you need to understand that whatever happens in cyberspace is going to have bleed over. So are we now going to start thinking, as the Dutch have and as the Americans seem to have in cyberspace about severity, are we going to start using severity as our measurement in other areas beyond cyber? I think this is a very interesting question.
So when we're dealing with ambiguity, maybe there's a gap here. If you look at the SIGINT, the HUMINT that's been developed, for example, around terrorism, and now you see it's been applied to human trafficking. So now we have all kinds of information about what happens with a Super Bowl. So the bottom line here is that we're developing processes now which sooner or later we're going to convince ourselves are predictive. Before there's been anything that, no matter how you define attack, there's a potential for an attack. And so now we're moving from law being a reactive process to a proactive, to a preemptive process, whether it's, criminal, law enforcement, it's military, whatever it is. So where's the development of law that's going to deal with this future that's coming? Because as we're able to crunch more and more information, people are already starting to stand up and say that they can predict things, they can predict conflict, they can predict attacks. You know, all the studies that are being done with radicalization, and when does somebody's ideological radicalization actually transfer into, you know, an actual terrorist act, for example. So where is the transition here in international law to deal with this process as we move forward there?
Can I just tag on to that? Because Sean, I think you dealt with this a little bit. I mean, you talked about how the law is reactive and maybe, you know, should it be proactive? But the law plays, especially in IHL, a signaling role, right? I mean, it signals to nations how they can work to develop rules, how they can work to develop weapons, in fact. You know, so doesn't that signaling role, isn't that important? And shouldn't we be looking with the law to use it as a signaling role, particularly in areas like cyber or emerging technologies?
Yeah, I guess in a sense that anticipates desirable outcomes, perhaps, but I'm skeptical of states' trust of the international legal system to do that for them. That if we think that the law appears deficient or isn't in a state that permits us to say that there are clear standards for evaluating those threats presently, I think a lot of that is deliberate. I think Mike's point provoked the thought to me about the collective security arrangement of the United Nations Charter. That sure, you see movement, you see statements from the Dutch or perhaps from the U.S. that suggest that use of force ought to drift a little bit, or that one or another threshold ought to move a bit. But at some point, I think we have to grab a hold of ourselves as international lawyers and say, wait a second, these aren't adjustments, this is an abandonment. The states have finally given up on this collective security apparatus, that they're just no longer willing in some contexts to surrender decisions about when to do certain things in a given sphere. And they're still saying all the right things, and I hadn't realized the Russian and Chinese commitment to the UN Charter system had taken place. I was aware of those treaty proposals, but at some point, you know, we've worked all the magic we can with that UN Charter language, and we've become so detached from its original purposes or from the bargain that was struck in that document that maybe they're just giving lip service to it.
I was intrigued by the reference to deterrence, but I was wondering whether this notion can work at all in the cyber context. Because I mean, I can see how it works in a nuclear context. You know where the attacks may come from, and you know who to target as a reaction, also to deter a possible first strike. But in the cyber context, going back to what we were saying early this morning, is there a point in the United States saying to China, if you do it again, then we are going to do this and that, when China will always, at least as far as we know, be able to plausibly deny the responsibility for that. And I guess this problem also applies to possible treaties with that may prohibit at least the use of the weapon against a certain target or not. I mean, won't the states just ratify them if they have a reasonable expectation that they won't be caught red-handed anyway? It seems just too easy, right? I mean, it's a win-win situation for them. You look good because you ratify the treaty, but you know that you won't be found responsible. So again, we go back to the preliminary question of identification and attribution. Doesn't everything depend on that?
So I think there is still a role for deterrence, even with the attribution difficulties in cyberspace. And this goes back to a point from either earlier today or yesterday that, I guess it was the first panel this morning. You know, when you're thinking about evidence of who is carrying out a cyber attack, it's not just the forensic evidence. I mean, you can look at what's attacked, who has capabilities sufficient to carry out such an attack. So I think that there is a role still for deterrence, and I think we're seeing that play out. You know, between the U.S. and China, you know, we haven't seen exactly the scenario of, you know, if you steal IP, we will do X exactly. But about a year ago, the U.S. released its strategy on trade secret theft. It was a detailed exposition of several steps that the United States was going to take, and this was in the context of the Mandiant Report and a lot of build-up identifying China as a major source of intellectual property theft. And so the United States came out with this strategy that talked about increasing law enforcement with respect to cybercrime and theft of trade secrets. It talked about trade remedies. It talked about public education. It talked about all these steps. So that's not exactly the law of war context, but I think we are seeing it in the cyber context, this idea of deterrence. Certainly trade remedies is a threat that the United States was making. And I think in the law of armed conflict context for cyberspace, deterrence still has utility because we can look to real-world facts to figure out attribution, not just the forensics. So I think deterrence is not an unhelpful concept in cyber.
You can also note there is back-channel deterrence as well. I mean, the point that Derek made is a wonderful one. It's the unknown, unknown, unknown. It's super, super duper classified. It's beyond top secret. The problem isn't so much attribution. I'm told by the experts, I certainly don't know, that you can attribute a great many attacks. The problem is you don't want to reveal that you can attribute the attacks because then it reveals your capabilities. You know, and that's what you're really worried about. It's not that attribution is hard, it's that you don't want them to know that you have the capabilities to attribute, because this reveals your unknown, unknown, unknown. But you could do, I agree with you, you can do this back channel. I mean, you can tell the Chinese, listen, we know you did it. We know you did it, you know, and they will receive that message. And then, of course, remember, it's deterrence. You can strike at them in a way that is also can't be attributed, but they know you did it. So, I mean, you can have this sort of subsurface signaling going on that I think would enable deterrence to work to some degree, although not in the classic way, not in we're going to nuke you sort of way. That it'll be more elegant deterrence.
And it's only bilateral deterrence, it's not multilateral deterrence.
Yeah, but the thing what makes deterrence work is the wondering on the other side. You know, so it's not just they know we can nuke you, you know, we can nuke them. It's also they wonder what we could do with them, you know, and those things.
I had a question. Are there any, I was thinking about the uncertainty issue too, and building off of that. Would there be any way to deal with that on an international level, or through international agreement, or just that particular issue of, I mean, we talked about usually you can attribute an attack. There seems like more so based on previous discussions that it's hard to nail it down, and it's not like a missile, and it's not like the conventional weapons that we deal with. And so considering that, is there any way, how could we approach that internationally, or how could we reach an agreement to deal with that uncertainty? Does anyone, I mean, is that the whole problem here? Is that how cyber warfare is unique, and that there's something that we just can't get at? Is the problem, is there even a solution, I guess, internationally?
Well, I never know who to believe about attribution. Every time a technician tells me that, yes, I can with 100% certainty, given the time and resources, figure out where every cyber attack emanated from, I have another tell me that no, anonymity is achievable. Perfect anonymity exists. So I'm at a loss for whom to really believe.
Case by case. I mean, sometimes you know, sometimes you don't.
I suppose so. And if that's the case, and if states are getting similar evidence or feedback, I'm really skeptical of their willingness to commit to any standard in international law. Why would they trust the international legal system with this issue if they haven't even sorted it out domestically? What signs of reliability has the international legal system historically shown to sort these things out fairly, equitably, on a principled basis? Are IC judges really that great? That they can figure this stuff out for us? I don't think states think that's the case.
Okay, thanks. Are there any other questions from the audience?
You mentioned just now that most states who are currently major actors, for a number of different reasons, don't have incentives to kind of make this law clear and plain and make all these things known. Is it possible that you could get an international treaty actually from the majority of states in the world that right now aren't these major players, but are in fact the very states that would be easiest to be subject to these kinds of attacks? Does that idea have any credence to you? Could something move forward if that were the perspective of how to do a treaty?
Look, I think it's an interesting thought. Is it possible? Yes. I mean, I suspect that if you could cobble together a rather large number of states that are relatively disinterested in some of these larger strategic concerns, the question would be at the end of the day, what difference might it make? Does it create a kind of normative pressure? It might. But given that we're already talking about existing international rules that come with enormous normative pressures, the charter frame, international humanitarian law, I think we're already in a realm where there's a tremendous amount of normative weight to the rules that clearly apply in the cyber context, just unclear how exactly they apply, the extent to which they apply to specific actions in cyberspace. I don't know how much more leverage you can obtain normatively just by engaging in this sort of exercise of not worrying about getting any of the important players to the table. Let them be outsiders and feel the pressure of being outsiders. That works in some contexts. Human rights law, it's worked really quite well on some issues in human rights law. I'm more skeptical of it working in this kind of context.
There's also a problem. There's also a problem with getting those lesser states. You have to remember that cyber is the great equalizer. So if we're talking about conflict issues, the military of Belgium never can compete with any of the big militaries, the United Kingdom, the United States, and so forth. But once they're armed with cyber, this means that states that don't have much kinetic oomph suddenly have enormous capability. You don't need an air force to engage the enemy air force in air-to-air combat and shoot their aircraft down. You just ground their air traffic control system, their command and control system, et cetera, et cetera, et cetera. So, I mean, it's an interesting notion, but they're the very states that should want to preserve the capability because they don't have the other capability. So there's a logical problem there as well.
Thank you.
You use the cyber network to take control of their drones and turn their drones against them.
This could never happen.
Of course not.
I think there's a movie on that. And on that note, we're going to conclude this panel. Big thanks to our panelists here.
So we originally were going to have a coffee break and then come back for a concluding discussion among the panelists in order to allow other panelists to respond to what they've heard. But that's actually happened quite a fair amount throughout. So I think that we'll skip that. And in lieu, I will give the floor to Rebecca Sills, our next volume's editor-in-chief, and she'll wrap up for us now.
Good afternoon. My name is Rebecca Sills, and I am the incoming editor-in-chief for Volume 50 of the Texas International Law Journal. I would first like to thank the panelists for traveling from very near and very far, as far as London, to participate in this year's symposium on cyber warfare. And we would also like to thank the Strauss Center for their support. In the past 2 days, we've learned more about the development of the Talon Manual, and the rigorous and ongoing debates surrounding the creation of that manual. We've learned about the evidentiary burdens that arise in cyber warfare and witnessed a debate regarding legal gaps around how international law applies. The scholarship resulting from this symposium will be published in issue 2 of volume 50 next year. It is a special year. As you may know, it marks our 50th anniversary. And the legal issues surrounding cyber warfare discussed here serve as an excellent catalyst for looking at the historical context of international law, as well as where international law is going, ideas we wish to touch on in the upcoming issues. Our first edition of TILJ had an article about the law of the seas, and it was published in a time when the rights and responsibilities of states and their territorial sea were in flux. Now, cyberspace is the new sea, with ill-defined boundaries and underdeveloped rights and responsibilities of actors. Today, the law of the seas holds no such ambiguity, and perhaps in 50 years, the law of cyberspace will be just as well defined. The scholarship produced by this conference, the speakers, and from the Talon Manual could easily be seen as the first step towards diminishing this uncertainty. I look forward to reading and publishing what are sure to be intellectually invigorating, insightful, and most importantly, punctual submissions. Just as a reminder, Ms. Eichenhauser and Professor Jinks are hosting a panel on this similar topic at South by Southwest on Sunday at 3:30. And I would like to thank you again for your attendance. Thank you.